Chris, last night we learned and were able to confirm that at least 4, and now we are hearing possibly 5, senior leaders of the criminal section of the Civil Rights Division resigned in frustration over the failure of their office, in their view, to actually defend the constitutional rights of all Americans. Part of the concern for several of them, we were told, was the department's titular head basically saying we're not investigating the use of force in the ICE officer who fatally shot Renee Good in Minnesota. This was disturbing to many in the Department of Justice.
Breaking tonight, the damage is already done. Senior leadership inside the Department of Justice's Civil Rights Division has begun walking out the door, not quietly, not politely, but in open frustration, signaling a rupture at the core of federal law enforcement. Careers are being abandoned, pensions are being risked, institutional memory is evaporating in real time. This is not a future problem. This is the consequence now. Watch it happen. Picture a federal division built to enforce constitutional rights losing its most experienced prosecutors because the department has decided not to act. The shock lands first because the stakes land first. At least 4, possibly 5, senior leaders of the criminal section of the Civil Rights Division have resigned. These are not junior staffers. These are the people whose job, whose mandate, whose professional identity is to investigate fatal uses of force by federal officers. Their exit is a flare shot into the night sky. Something fundamental has stopped functioning. When the guardians leave the gate, the message is unmistakable. The gate is no longer being guarded. The immediate catalyst is the fatal shooting of Renee Good by an ICE officer in Minnesota. Normally, this is automatic. A federal officer uses deadly force and the Civil Rights Division opens an investigation. Not as punishment, as a process, as law, to determine whether the force was justified, whether it was legal, and whether it crossed the constitutional line. That process did not happen. Instead, within 48 hours, the president and vice president publicly declared the shooting justified. No probe, no review, no pause. The verdict was delivered before the evidence was gathered. Inside the department, that decision detonated. Prosecutors trained to follow the Justice Manual, the operating playbook of the DOJ, watched their own leadership declare indifference to the very function their office exists to perform. Indifference is the polite word. Hostility is closer to the truth. Reporting indicates the department is treating the incident not as a possible civil rights violation against Ms. Good, but as a potential assault on a federal officer. The frame flips instantly. The victim becomes the aggressor. The shooter becomes the protected party. Now, layer the refusal to cooperate with Minnesota state authorities. Add the exclusion of the FBI, an agency with deep expertise in use of force investigations. Add the Assistant Attorney General retweeting warnings that ICE officers will use deadly force. Add public declarations that civil rights enforcement is not woke ideology. This is not subtle. This is not bureaucratic drift. This is an announced posture. The stakes are not abstract. Civil rights enforcement depends on credibility. It depends on the belief that investigations are mandatory, not optional, and certainly not political. When senior prosecutors conclude that the core function of their division is being intentionally abandoned, they face a choice: comply or leave. Many are leaving. Others are burrowing in, protecting pensions, healthcare, income, waiting it out. That is not a healthy institution. That is an institution under siege from its own leadership. This is where the shock becomes systemic. The Civil Rights Division is not an isolated office. It sits alongside the Public Integrity Section, the Tax Division, and task forces targeting kleptocracy and crypto-enabled crime. Reporting shows those units being dismantled as well. 75% attrition in key areas. This is a pattern. Enforcement aimed at corruption, abuse of power, and wealthy criminality is shrinking. Enforcement aimed at political enemies is expanding. The immediate consequence is already visible. Expertise is gone. Norms are broken. And the message to every federal officer is clear. If the politics align, scrutiny evaporates. That is the opening reality. That is the damage on the ground before any theory, before any justification, before any spin. The law is not being applied evenly, and the people tasked with applying it are refusing to participate. Reset the frame. This is not about ideology. It is not about sympathy. It is not about whether one personally believes the shooting was justified. The law does not operate on belief. The Department of Justice operates on process. The Justice Manual exists precisely to remove political instinct from prosecutorial decision-making. It outlines incentives, obligations, and triggers that require investigation. A fatal shooting by a federal officer is one of those triggers. Full stop. The Civil Rights Division's criminal section has a narrow, defined role. It investigates whether federal agents, acting under color of law, violated constitutional rights. That duty exists regardless of outcome. Even when investigations conclude no charges are warranted, the investigation itself is the safeguard. It is the mechanism that tells the public the system examines itself and applies the same rules it enforces on others. By declining to investigate, the department short-circuits that mechanism. This is not discretion in charging. This is a refusal to examine. Brendan Ballou, a former federal prosecutor and DOJ National Security Division lawyer, described it accurately. There are all sorts of incentives baked into DOJ policy for this office to be involved. Ignoring them is extraordinary. Doing so while senior political leadership publicly declares the case closed is unprecedented. Legally, the problem compounds. When federal authorities refuse to investigate and also refuse to cooperate with state authorities, they create a jurisdictional vacuum. Normally, overlapping investigations provide redundancy. Federal and state systems cross-check each other. Here, both are being shut out. That is why observers describe this moment as uncharted territory. The guardrails are being removed simultaneously. Then there is the signaling. An assistant attorney general retweeting warnings that deadly force will be used is not neutral communication. It is advocacy. When that same official declares the job is to enforce civil rights laws, not woke ideology, the subtext is explicit. Certain categories of civil rights enforcement are no longer priorities. Harmit Dillon has been clear about this view. She has said investigating law enforcement agencies for potential abuse of force is annoying. Annoyance, however, is not a legal standard. Paul Butler, former federal prosecutor and Georgetown law professor, framed it plainly. Excluding internal experts from an investigation into a civilian's death, excluding state authorities with expertise, and excluding the FBI raises a singular suspicion. The motive is not truth-seeking, it is narrative reinforcement. The department appears focused on aligning its posture with statements already made by the President, Vice President, and Secretary of Homeland Security. Legally, that alignment is corrosive. Prosecutorial independence is not ceremonial, it is functional. Once prosecutors are perceived as protecting leadership rather than applying statutes, the legitimacy of every subsequent action is questioned. That includes actions against political opponents. That includes actions against ordinary citizens. Selective enforcement poisons the well. This is why the resignations matter. Prosecutors are conservative by nature. They do not leave lightly. They leave when they believe participation itself creates liability, ethical or historical. When Ty Cobb, a former Trump White House attorney, calls the refusal to investigate a clear indication of authoritarianism permeating the DOJ, that is not partisan hyperbole. It is a description of institutional inversion, justice for allies, scrutiny for enemies. Legally, the consequences cascade. Courts rely on DOJ credibility. Judges defer to representations made by prosecutors. When that credibility erodes, judges respond with skepticism, closer oversight, and rejection. The department's choices today shape its reception tomorrow. That is not speculation. That is how courts work. The trust reset is simple. Either the DOJ applies the law consistently, or it becomes another political instrument. The law anticipates this choice. It was designed to prevent it. The current posture is testing whether those designs still hold. Now watch the escalation. It is not loud, it is cumulative. Courts notice patterns. Judges notice omissions. Investigators notice when referrals stop arriving. The image presented to the public is strength, decisiveness, and control. The reality underneath is fragility. A department shedding expertise while insisting it has matters under control is not projecting confidence. It is a broadcasting vulnerability. Consider the contradiction. On one hand, the administration declares the shooting justified almost immediately. On the other hand, it insists that no investigation is necessary because the facts are already known. That posture collapses under minimal scrutiny. Facts are established through investigation, not proclamation. Courts do not accept conclusions without records. When the record is empty, the conclusion is hollow. Escalation also arrives through selective aggression. The DOJ has pursued named political enemies aggressively: James Comey, Letitia James, John Bolton, and Jerome Powell. Simultaneously, it has dismantled units designed to pursue corruption, tax crimes, kleptocracy, and crypto-enabled financial misconduct. The pattern is unmistakable. Enforcement is not shrinking uniformly. It is being redirected. This is where image and reality diverge sharply. The image is law and order. The reality is selective law and order. That distinction matters because the rule of law depends on predictability. When enforcement becomes conditional on loyalty, the law ceases to be law and becomes leverage. Inside the department, that divergence produces humiliation. Not emotional, but professional. Career prosecutors trained to follow evidence are sidelined. Experts are excluded. Decisions are made above them and around them. Their role becomes ornamental. For professionals whose identity is bound to the integrity of the process, that is intolerable. Leaving becomes the only way to avoid complicity. Publicly, the humiliation is quieter but no less real. When the Wall Street Journal reports that President Trump has complained privately that Attorney General Pam Bondi is weak and ineffective, despite her apparent compliance with his directives, the contradiction sharpens. What more could be demanded? According to Paul Butler, she appears to be the attorney general of his dreams, marching to orders, prosecuting perceived enemies, and excluding experts. And yet, dissatisfaction persists. That dissatisfaction hints at demands that even this DOJ may hesitate to fulfill. This is escalation through pressure from above and below. From above, political demands intensify. From below, institutional capacity erodes. Courts, meanwhile, are not static. Judges read the news. They see attrition rates, they hear testimony. When DOJ representations are challenged, the department's weakened internal structure makes defense harder. The image of control fractures further when sources describe desperation inside the DOJ. People are leaving not for better jobs, but to escape. Others stay only to protect benefits. That is not an institution executing a clear mission. That is an institution managing fear. Image versus reality collapses completely when enforcement priorities are stated openly. Harmit Dillon has articulated skepticism toward core civil rights enforcement. She has dismissed investigating systemic abuses as too annoying. Those statements are now matched by action. Investigations are not happening. Experts are excluded. Resignations follow. The escalation is not dramatic, it is procedural. It is the slow tightening of consequences as each choice narrows future options. Courts grow wary. State authorities grow suspicious. The public grows distrustful. None of that requires rhetoric. It requires time. Time is already passing. At this stage, the collapse is structural. You cannot maintain the image of equal justice while dismantling the machinery that produces it. The system does not self-correct through messaging. It corrects through enforcement or it breaks. We are watching which path is being chosen. At this point, lay out the options, because there are options, but none are clean. Option 1, reverse course. Open the investigation into the shooting of Renee Good. Invite state authorities, include the FBI. Follow the Justice Manual. This option restores some credibility, but it collides directly with public declarations already made by the president and vice president. Reversal would be an admission that those declarations were premature, politically costly, institutionally necessary. Option 2, maintain the current posture. No investigation, no cooperation. Narrative locked. This option deepens the credibility crisis. Courts will not forget the absence of a record. Future cases will carry the stain. Every prosecution brought by this department will be evaluated through the lens of selective enforcement. Judges will compensate. Defense attorneys will exploit. Losses will follow. Option 3, partial compliance. Limited internal review without transparency. This option satisfies no one. It does not restore trust internally because experts remain excluded. It does not satisfy courts because partial records invite skepticism. It extends the crisis rather than resolving it. Each option carries consequences. The department has already chosen a version of option 2. That choice frames the rule of law question starkly. The rule of law is not about outcomes. It is about the process applied consistently. When leadership substitutes loyalty for legality, the rule of law degrades. This degradation is not theoretical. It manifests in dismantled task forces targeting financial crime. It manifests in attrition rates. It manifests in prosecutors describing the DOJ as hostile to its own mission. When the infrastructure for enforcing laws against the powerful is removed, accountability flows in only one direction. Rule of law framing demands clarity. The DOJ exists to serve the United States, not a president. When prosecutors behave as though their client is an individual rather than the Constitution, the department becomes a private law firm with public power. That is the danger articulated by multiple former prosecutors watching this unfold. The humiliation phase deepens here. Not because anyone is embarrassed on television, but because the institution's self-image collapses. The DOJ has long styled itself as independent. That claim is now contested by its own alumni. When former Trump White House counsel Ty Cobb describes authoritarianism permeating the department, it signals a cross-ideological alarm. This is not an opposition talking point, it is an institutional warning. The rule of law also requires functional capacity. 75% attrition in critical sections is not survivable without consequences. Training replacements takes years. Institutional knowledge cannot be reconstituted overnight. During that gap, enforcement falters. That faltering will be visible in court outcomes, settlement decisions, and declined cases. This is where political and legal pressures converge. Politically, the administration seeks loyalty and speed. Legally, the system demands deliberation and independence. Those demands are incompatible. The current trajectory resolves that incompatibility by sidelining the law. The options are narrowing because time narrows them. Every day without investigation cements the precedent. Every resignation increases the cost of reversal. The department is choosing to absorb that cost rather than confront the implications of its earlier statements. The rule of law does not announce its collapse. It erodes through exactly this sequence. Exceptional cases become exceptions to process. Exceptions become norms. Norms become policy. By the time the erosion is undeniable, repair is expensive and slow. That is the frame. Not outrage, not panic. Structural analysis. The DOJ is operating in a way that forces a reckoning with what equal justice actually means when political loyalty is prioritized. The fallout is already spreading beyond the department. State authorities excluded from the investigation are not passive. They document. They preserve. They speak later. Courts do not forget being cut out. Legislators notice attrition. Oversight hearings follow patterns like this, not single events. The institutional memory of this period will be written by those who left and those who watched them leave. Politically, the administration faces a narrowing field. Aggressive prosecutions of perceived enemies may satisfy immediate objectives, but they carry downstream risk. When enforcement appears selective, future administrations inherit a weakened DOJ. That weakness does not respect party lines. It constrains everyone. Institutionally, the Civil Rights Division's hollowing out leaves communities without a federal backstop. Historically, that division investigated patterns of abuse, protected voting rights, and enforced constitutional guarantees. When leadership declares those efforts annoying, the signal to local law enforcement is unmistakable. Oversight is optional. Consequences are negotiable. The inevitable ending emerges not as drama, but as arithmetic. Fewer prosecutors plus fewer investigations equals fewer credible cases. Fewer credible cases plus heightened judicial skepticism equals losses. Losses erode authority. Authority once lost is difficult to regain. President Trump's reported dissatisfaction with Attorney General Bondi underscores the instability. Even maximal compliance may not be enough. When demands escalate beyond legality, officials face a line. Some cross it, some leave. The department has already seen which choice many are making. The American public is not required to master the details of DOJ policy to grasp the significance. They need only observe the pattern. Investigations declined, experts excluded, prosecutors resigned, enemies pursued. That pattern tells a coherent story. It is not subtle. In the end, systems built on rules either enforce them or abandon them. The DOJ is signaling which path it is on. Courts will respond accordingly. History will record the moment not by press releases, but by attrition numbers and case outcomes. Imagine the final ledger. The Civil Rights Division diminished, task forces dismantled, trust fractured, judges skeptical, prosecutors gone. That ledger does not balance in favor of power. It balances in favor of accountability, delay, and damage done. There is no cliffhanger here. The trajectory is visible. Institutions that trade independence for loyalty do not regain independence without cost. That cost is already being paid by those walking away. The inevitable ending is this: a Department of Justice that abandons neutral enforcement cannot command lasting authority. The law will assert itself eventually through courts, through oversight, through history. The only question left is how much institutional damage will be absorbed before that assertion becomes unavoidable.